All right, let's get right into it. We text all day, every day, right? And we kind of think those conversations are private. But what happens when those texts end up as evidence in a police investigation? Today, we're going to break down a really important Supreme Court of Canada case that pretty much sets the rules for all of this.
I mean, this is the question at the heart of our digital lives, isn't it? You hit send, the message disappears from your phone, but it's still out there, somewhere, sitting on a server. So can the police just go and grab it? Well, the answer is way more complex and, honestly, a bit more surprising than you might think.
And that answer comes from this one case, R.V. Jones. It really forced Canada's top court to figure out how to balance our right to privacy with the tools police need to solve crimes. So let's dig into the story behind this huge ruling.
Now, this whole legal debate didn't just happen in a vacuum. It all started with a real-world police investigation into a man named Tristan Jones.
So here are the basics. Tristan Jones was facing some serious charges, trafficking firearms and drugs. And the key evidence against him? It wasn't a hidden weapon or anything like that. It was a bunch of text messages. But here's the really interesting part. The police didn't get the texts from Jones's phone. They got them from the TELUS account of the person he was supposedly working with. And this is the detail that the entire legal fight is about. To get those texts, police used what's called a production order. You can think of it as a formal request for records that already exist. What they didn't get was a wiretap authorization, which is way, way harder to get and is used for live spying. The whole case really hangs on this one question: did they use the right tool for the job?
So this led the Supreme Court to its first big hurdle. I mean, if you send a text and it's now just sitting on a TELUS server somewhere, a server you don't own, you don't control, can you still claim it's private? Do you even have the right to challenge the police for looking at it?
To figure that out, the court had to use this really important legal idea, the reasonable expectation of privacy. This is the test from our Charter of Rights that basically decides if you even have the right, the legal standing, to argue a police search was unconstitutional. You know, no expectation of privacy, no right to complain. Simple as that.
And the court kind of follows a four-part recipe to get there. First, what exactly was searched? In this case, it was the electronic conversation. Second, did Jones have a direct interest in it? You bet. Third, did he personally think it was private? And fourth, and this is the big one, is that feeling of privacy something that society as a whole would say is reasonable?
But here's where it gets tricky. This created a perfect legal trap for Jones. How could he possibly stand up in court and say, hey, I expected those incriminating texts to be private without basically admitting that he was the one who wrote them? It's a classic catch-22, right? Protect your privacy and you might just confess to the crime.
The Supreme Court saw this problem and came up with a really smart solution. They said an accused person doesn't have to incriminate themselves. They can just point to the prosecution and say, look, for the sake of this argument, let's just assume you're right and I wrote those texts. Now, can we talk about my privacy rights? It was a massive move to protect the rights of the accused.
Okay, so with the court agreeing that Jones had a right to privacy, they moved on to the second huge question. Did the police use the right tool to get the texts? Was that simple production order enough, or should they have been forced to get a high-level wiretap authorization?
And this slide really lays out the difference perfectly. A production order is for the past, for historical records just sitting on a server. It's way easier for police to get. A wiretap, on the other hand, is for the future. It's live interception of messages as they happen. The legal bar for that is sky high, and for good reason. It's one of the most invasive things the police can do. So the whole debate boils down to this. What exactly is a text message once it's been sent and is sitting on a TELUS server? Is it just a historical document, kind of like an old letter? Or is grabbing it from the server still a form of interception, just delayed by a few seconds? The answer to that question changes everything. So after hearing all the arguments from both sides, the Supreme Court of Canada was ready to deliver its final verdict, a decision that would set a huge precedent for digital privacy in this country. Let's see what they decided. So, the court's decision was split, in a way. On that first question about privacy, they sided with Jones. They ruled that, yes, you absolutely do have a reasonable expectation of privacy in the texts you sent, even if they're on someone else's server. But, and this is a big but, on the second question, they sided with the police. They decided the production order was the right tool because the texts were historical data. They had already been sent, delivered, and stored. It wasn't a live intercept. So the final result was pretty straightforward. Because the court said the police used the right tool, the text message evidence was totally legal. Tristan Jones lost his appeal, and his convictions were upheld. But hang on, the story isn't quite over. Because even though that was the final ruling,
The court was deeply divided on this issue. The 7 judges were not unanimous, and honestly, the disagreements are just as important as the decision itself. They really show the tension here.
This table breaks it all down perfectly. You have the majority, who created that clear line between past and future data. But then it gets really interesting. You have a concurring opinion, someone who agreed with the result but for different reasons, who basically sounded an alarm. And then you have a full-on dissent, arguing the majority got it totally wrong. Let's dig into why.
Justice Rowe, who wrote the concurring opinion, pointed out a huge practical problem. He said, look, if a company like TELUS stores texts, even for a minute, police can just use the easier production order to get them almost instantly. It's a backdoor way to avoid getting a tough wiretap warrant. But if your provider doesn't store texts, well, then the police have no choice but to get a proper wiretap. He saw a major loophole. And Justice Abella, in her dissent, was even more direct. She dropped this powerful quote, saying that a fundamental right like privacy shouldn't be a lottery that just depends on which cell phone company you happen to use. Your protection shouldn't change just because you're with TELUS instead of Bell.
Her main argument was both simple and profound. A text exchange is a conversation, period. It doesn't matter if the police grab it a second after it's sent or a week later, they are still getting into a private conversation. And for that, she argued, they should always have to meet the highest legal standard there is, a wiretap.
So after all of that legal debate, what does this actually mean for us? For our texts, our DMs, and our rights in this digital world? Let's boil it all down to the key takeaways. Okay, here's what you need to remember. First, the good news for privacy. The court confirmed you have a right to privacy in your sent texts. That's huge. Second, the practical reality. Police can get those texts once they're stored, using a production order, which has a lower bar than a wiretap. And third, and this is the real kicker from the disagreement, your actual level of privacy protection could literally depend on your cell carrier's internal data policies.
And that leaves us with this final, really thought-provoking question. The Supreme Court tried to draw a clear, technical line. But in doing so, did it accidentally tie one of our most important digital rights to the fine print in our cell phone contracts? That's a question we're all still trying to figure out today.